DUI tracking system. The Washington State Liquor Control Board is a regulatory and a law enforcement agency, and they work with all other law enforcement agencies for the end result of two words, which is public safety. One of the tools they use is the WSLCB DUI tracking system. When a person is cited with a DUI, the police officer will ask the cited individual where they had their last drink and their BAC. This information is provided to WSLCB, and officers monitor this information to identify possible violations. Remember, these are alleged, and the officers will not issue a citation based on this report. Once an establishment gets on this list, a LEO, liquor enforcement officer, will come to you and try to help you with your over-service problems. When 50% of all DUIs come from people drinking in on-premise licensed locations, this is one of the ways that WSLCB is working to ensure public safety. Third-party liability. What are the potential legal consequences of over-serving or serving minors? You could face numerous consequences. Licensing consequences. You could lose your permit, and your employer could also lose their license. Civil consequences. You could owe millions of dollars to third party, innocent victim who were affected by a customer you overserved. Since 1933, the law in the state of Washington has been as follows. No person shall sell any liquor to any person apparently under the influence of liquor. This is the same standard that will be used in a civil suit against a server. Courts analyzing that language have stated that the relevant question is the appearance of the person at the time the alcohol was served. A third-party alcohol liability lawsuit is this. If you sell or serve alcohol illegally to a minor and or AIP, and they cause bodily or property damages to a third party, an innocent victim, you could be liable for the damages. There are three parties involved in a third-party alcohol liability lawsuit. You have the first party, is the drinking party, that is the customer. The second party is the serving party, that is you and the establishment. The third party is the person or property outside of the alcohol transaction, the person who was injured, the property damage. Here's an example. Mrs. Jones comes into your bar, she sits down and you serve her some Merlots. And after a while, she starts to show signs of intoxication, and you tell her that you'll have to stop serving her alcohol. She then gets up and leaves, and you do nothing to stop her. You might make a comment to her like, "Are you okay to drive?" Then Mrs. Jones says, "Yep, I'm fine," and she heads out the door. While she's driving around on the road, here comes Mr. Smith, and she crashes into Mr. Smith's car and hurts him really bad. Here's what can and probably will happen. Mr. Smith will sue Mrs. Jones for hitting her. Then Mr. Smith can sue you and your establishment where you're serving alcohol for over-serving Mrs. Jones. These are not new alcohol liability laws. They go way back into England. They're part of the common law. Here's a quick trip to law school for you. A tortfeasor. A tort is a civil wrong. The category that you as a server can fall into is negligence. This tort requires 4 elements for it to be completed. A duty to another. This is created by common law. The common law is decided that it is common to the area of where you reside. If you were to serve alcohol to someone to the point of visible or apparent intoxication, you should get this person to safety. Yeah, you call them a cab, you call their friend, their spouse, or they just sit there until they get sober. Remember, if somebody's intoxicated at your establishment, not causing a problem, purchasing, possessing, or consuming alcohol, they are welcome to stay. Was there a breach of this duty? Did the server do nothing to stop this person from driving or walking away? Probable cause. Was it foreseeable that this individual, who is now intoxicated, that if they drove or walked away that something bad could happen? Obviously yes. And you have your actual damages. You've got your tangible damages such as property damage, lost time from work, medical costs, etc., as well as other tangibles, i.e. pain and suffering. All of those involved in the alcohol transaction can be named in the lawsuit. The manager, host, hostess, valet attendant, bouncer, etc. will all be named in the lawsuit. 51% of the jury can be enough to convict, and only 51% of the burden of proof has to be placed upon you. A law journal reports that 80% of these lawsuits will be settled out of court for $100,000 or more. The cases have multiplied by 300% in recent years. Who can sue me? The person injured can sue you. This includes someone who chose to get into the car with the person you overserved. This also includes innocent bystanders who were harmed. The family of the person injured can sue you. The person's parents, children, stepchildren, and or spouse can all sue you. Each can claim his or her own damages. If there's a death, then the group of people who can sue you gets even bigger, expanding to brothers and sisters. Sometimes the person you overserved can sue you, particularly if that person was a minor. If that person dies, his or her family members may still be able to sue you. What types of damages will I have to pay? Well, you would have to pay for the injured person's pain and suffering, both the suffering already experienced and to be experienced in the future. The injured person's lost earnings. If the person died, that would be that person's projected lost earnings over his or her lifetime. You may have to pay for the injured person's medical and hospital expenses, even if that person had insurance. You could be sued for the loss of certain relationships. If a parent died, the child can sue you for losing out on having a mom or a dad. If a child died, the parent can sue you for losing out on having a child. If a spouse died, the spouse can sue you for losing out on having a spouse.